Hello and welcome everyone to the National Veteran Small Business Coalition's virtual training series. I'm thrilled to have Chris White back from Clark Hill. And Chris, I'm looking forward to this bite-sized training. It looks like we're talking about the changes clause. Oh my, everything, how it works and how to protect your rights and all about those good contract changes. And we don't have any of that going on right now, do we?
Not even a little bit. Not even a little bit.
Not even a little. All right. With that, Chris, I'm going to turn it over to you, and I'm going to go into stealth mode, and I'll question fairy will pop in from time to time.
That sounds fantastic, Marie. Thank you. And thank you to the National Veteran Small Business Coalition for having me on to talk about another topic that I think is relevant right now, as Marie mentioned. So we are talking about the changes clause under FAR 52.243. And I am Chris White. As Marie mentioned, I am an attorney with Clark Hill, and I work in our government contracts and regulations space, as well as our lobbying branch and our economics branch. So FAR 52.243 specifically mentions that if any change under this clause causes an increase or decrease to a contractor's cost of or the time required for the performance of any part of the work under this contract, whether or not changed by any such order, the contracting officer shall make an equitable adjustment and modify the contract in writing. And that's very important because in the world of contracting, and especially as small businesses that are eager to have their first contract or eager to build that rapport with the government, sometimes you can find yourself in a challenging spot where the government's asking you for something and you're not sure if it's appropriate or even allowed to ask for additional time or money to meet that need, or if they're even asking for an official change under the contract. So today we'll go through what are the changes clauses, what constitutes a change to a government contract, whether it's directed, general, constructive, or notice, how that affects the contractor via a change notice, an REA, and or a claim, and then best practices for REAs and claims, including the documentation and preparing for that REA or claim. So there are a lot of different changes clauses, as you can see listed here. These address, commercial products and services, changes of fixed price, cost reimbursement, et cetera, as well as the notification of change and how that should proceed. Under 43.201, which is important, the contractor must continue the performance of a contract as changed, except that in cost reimbursement or incrementally funded contracts, the contractor is not obligated to continue performance or incur costs beyond the limits established in the limitation of cost or limitation of funds clause. The contracting officer may issue a change order by electronic means without a specific form under unusual or urgent circumstances, provided that the message contains substantially the same information that the required form would require. This is important because you need to know whether or not you must continue working during dependency of a change contract, or whether you have to wait for documentation to come in and what documentation to receive. And so changes can be whether it's the terms and conditions of the contract, whether it's the scope or the type of work to be performed, or something as simple as, are you changing the color of the vehicle being made, the number of mirrors, the number of tires, to make it simple. But all of this must be in writing. And it must be in writing because that way it comes to the contractor in a standardized and specific format to allow the contractor to ask questions and to allow the contractor to present to the government what change would require from them, whether it's an increase or decrease in price, or whether it's a lengthening or shortening of the period of performance. So directed changes are what you typically see in a contract and what you want to see. It's a unilateral change. This change clause allows changes within the general scope of the contract. It's usually by mutual or it can be bilateral agreement, and it's a written order from the contracting officer, and it has to come only from the contracting officer, not from a technical representative or an agent or someone else on the contracting officer's team. It must come from the contracting officer themselves. Even though other parties may be delegated in writing, absent having that delegation in front of you or that written approval by the contracting officer to make changes, you must hear from the contracting officer. Even if another party has been delegated to speak on behalf of the contracting officer for a change, your best practice is to confirm any order, whether it be written or verbal, from anyone that's not the contracting officer, to request confirmation in writing from the contracting officer. To say that more simply, if anyone but the contracting officer asks you to make a change to your contract, you should send an email to the contracting officer or a letter to the contracting officer asking them to reply in kind, confirming that the change is requested by the government. That just protects you from any later on challenge or rejection of any cost incurred. If the contracting officer, similarly, if they provide a verbal order, best practice is, again, to follow up a verbal order from the contracting officer in writing, and that can be something as simple as an email where you state that you are simply memorializing your verbal conversation and the contracting officer has requested or directed a certain change to occur under the contract, and that the contracting officer either has or will issue a written order changing the contract. These are just ways to protect yourself to make it more simple to get paid. As mentioned, these changes are allowed with the general scope of the contract. However, this is not to be applied to cardinal changes, which are not allowed because those are out of scope. And so a cardinal change is a change that is beyond the scope of the original contract. As mentioned, if you're trying to build a vehicle for the government and they want to change simple aspects of the vehicle, that can be within the scope of the contract. However, if they decide they want you to now build a boat, then that's outside the original scope of the contract. Similarly, when you're doing a construction contract and you're working on a specific room, and now all of a sudden they want you to build a separate building or work on a totally different room, that's going to be outside the scope of the original contract, and that becomes a cardinal change to the contract. It can be more nuanced than that, and that's where, if you're uncertain about that, it's important to have someone you can contact to review it with you and to do confirmation. Or it's fine to express to the contracting officer that the breadth of the change that's being made appears to be what would be constituted a cardinal change, and to get the contracting officer's written opinion as to why it is not a cardinal change, or maybe they agree that it is. Tough to say. But the contractor, you'll be required to continue your work despite any of the changes while the parties resolve pay or time requested. What this means is oftentimes the defense the government may raise to an REA, request for equitable adjustment for period of performance or cost, is that a contractor stopping work caused additional cost or caused additional delay, so therefore they're not entitled to be compensated for the equitable adjustment being requested. So you should continue the work because you've already documented that the contracting officer is asking for that change, or the contracting officer has already issued a written order changing the contract, and therefore you're protected to continue the work and to submit that request for equitable adjustment to claim the costs or time that the change is required. So to expand a little bit more further on what a general scope of contract is, that's a time of performance, sometimes called a period of performance, which is hours per day, days per week, must be done, must be delivered, must be concluded by a set date. So if you are producing something for the government and they want it by September 30th, but due to their change, it now needs to be October 15th, that is a change because that's the time of performance. That is considered the general scope of the contract. Specifications and drawings, those are the general scope of the contract. So as mentioned before, if you're working on a building and there are specifications and drawing for a specific room, and they want to make changes within that specification, within that drawing for the room, that's a general scope of the contract. However, if there's suddenly a whole new set of drawings and a whole new specification that has to be added to it, and that's a totally separate room or building, that's where that starts to become a cardinal change because they're not changing the already provided specifications and drawings. Descriptions of services, those are general scope as well as place of performance. So again, if they contracted you to work in location A, and now they want to change it so it's location B, that's likely a cardinal change to the contract and one that would not be permitted under a changes clause. General scope continued. Nature of the work is a type of work requested essentially the same as the type of work originally bargained for. Did the parties reasonably contemplate that the work requested was when the contract was signed for? That means, is it reasonable to believe that when you negotiated for the original contract, that what they're asking for you to do now is something that could have been contemplated at the time, and so it's within that scope? Or is it just something that seems completely, out of left field? You're not really sure where it came from or how it got there. That's probably a cardinal change. Would the work requested be discovered as a result of the contractor's duty to inquire? That's when you start to talk about various construction, demolition projects, amongst other ones, where during your duty to inquire as to what all will be required by this contract, could you have found out about this? And therefore, that's probably part of the general scope. That doesn't mean because it's part of your duty to inquire, you don't get compensated for it based on a change. It just means it is a permissible change. And then, is the work requested essentially the same as originally requested work? This is important because it means, does your equipment still work for it? Do your people still work for the new contract? If they're asking you to do painting services and they add welding, you maybe don't have a welder on your team. So that starts to get outside of essentially the same as originally work requested. Another way that's a simple way is think of car headlights being round versus square, changing from diesel to petrol engines, changing color versus adding wings, changing a gas car into an electric car, or changing a car truck into a semi or other specialty vehicle. These are all things that can be used as a way to consider whether it's a general scope or whether it's a cardinal change of the contract. And finally, general scope talks about level of effort, cost, and disruption. So general scope, we start talking about defective specifications, bad faith conduct, or significant disruption. So when you start going into defective specifications and trying to correct those specifications, or if it's bad faith conduct by the government or significant disruption to work, that can start to edge away from general scope and edge into a cardinal change. Bad faith conduct is if the government knowingly doesn't include certain things in specifications, is aware of a differing site condition where you were led to believe you'd be digging into gravel and you get there and it's slate or stone. And so suddenly something that should have taken 1 or 2 days is going to take 3 weeks and require heavy demolition equipment. And the government knew about that. And it's going to cause a significant disruption in timeline, which is going to cause extra general conditions, extra time, extra cost, extra people, extra equipment. These are all things for consideration of whether it's general scope or whether you should be considering that this might be a cardinal change and therefore not something that's just permissible by change order. And that's where, but all of these items in here still fall under something that you should be requesting for a change to the contract if you're okay with doing it and letting the government know what the additional cost is and what the additional period of performance will be required. For these last three, if those are causing such significant disruption, significant cost, significant time changes that the government's not okay with it, that's likely also something that could be considered a cardinal change. And therefore, it's on them to decide that they're not going to proceed with the change requested, or that it requires a significantly different avenue to correct for because of how much the contract is changing. So constructive changes. These are changes of the contract by the government, but oftentimes the government attempts to deny that it's a change. These can be changes to express terms, failure to cooperate, interference with performance, or defective specifications. So many times the government may say something offhanded, or just be trying to tweak something small and they don't think it makes a big deal, but it is. Or if you were being asked to do a certain set of work, you've submitted an RFI to the government and 2 months go by and the RFI hasn't been answered and you can't proceed with work until the government responds to you and gives you the details you need. That's failure to cooperate. If the government shows up and tells you you can't work in a certain spot for some reason, but you need to in order to comply with the terms of the contract, the period of performance, so it increases cost or increases time, that's interference in performance. Similarly with defective specifications, as part of these contracts, if specifications are involved, there's supposed to be certain levels of percentages of specifications that are ready to go and to proceed. And that specification leaves something material or significant out. So you have to stop and wait for the government to correct that and provide the right guidance. These are all things that are constructive changes to the contract. So even though the contracting officer didn't come out and direct you to make a change or direct some modification to what you're doing, rather the government's actions or inaction is causing a change to the contract. That's a constructive change. that's still compensable via a request for equitable adjustment. So these are very important for you to spot as a contractor, because these are changes that you have to bring to the government's attention. And that's typically done through drafting a notice of change and making the government respond to the notice of change via a contract change, change mod, contract mod, some manner of written direction from the government acknowledging these constructive changes. So this is where thorough diligence and documentation is essential when monitoring the project. To protect your interest and to make sure you get paid, you must put the government on notice immediately upon discovering one of these constructive changes, including a demand for money and/or time as part of that notice to the government. It's not sufficient to simply say, hey, this is a constructive change, but you must say, hey, you've done X or you've not done Y. That's causing a constructive change. We need the contract modified to adjust for that change, which has caused X dollars and/or Y time in changes to the contract. And we submit that, and it will be followed up by a request for equitable adjustment based on that notice. But it's very important for the government to be aware of that. Yes, Marie.
Okay, so you've given a lot of great information. This is a common problem that runs, business owners will run across. They're out, let's say, on the construction site. We'll just or not only construction, but let's say an IT infrastructure implementation, an IT project. So we'll start with construction first. I've been an A&E type work. It's a construction build. I have the specs. Let's just call it a skiff, just for the sake of it. And I need to go ahead and I need to build the skiff. So I have my drawings and I'm building away, and then the project manager for the government comes in and says, we have this skiff we want, that you're building inside. Instead of 2 rooms, we now would like that broken out into 3 rooms, with the 1 room being set aside for meetings and the other 2 would be for offices. So now the drawings get modified, right? So the first thing I'm hearing from you is, once somebody says we need to kind of make a modification, is little alarm bells or little flags should be going off in front of me to say, hey, now it's like, I, as the business owner, may be thinking, yeah, I can do that, no problem. But project manager for the government, I need to go ahead and have a change request put in through your contracting officer, because this will modify my scope of work. Does the on-site rep or the on-site person even address that with the government project manager at that point in time? Or how is that broached? Because the business owner wants to maintain, a good working relationship with the technical line or the government project manager if they're building, a site. But at the same time, too, they're also thinking of the additional costs and the scope of work. Some people may call it scope of work creep, or, change modification. So I just want to make sure that, because I got a little bit confused when you said if it's still maybe like structurally the same, but slight modifications, the government may not view that as did I hear that right? Or I'm.
Yeah, you did. Those are all great questions and very well framing kind of what we're talking about. So I would say scope of work creep is a contract change. And so that scope of work creep could be a constructive change where the government hasn't acknowledged and said, hey, we are changing the contract. You need to do this now. But instead, it's kind of those one-offs of like, oh, well, while you're up there, do you mind also painting the ceiling? Or, oh, while you're in there, do you mind? But like,
exactly,
extra paint has a cost. Extra time has a cost. So those are all contract changes. So these constructive changes, yes, the government sometimes will not think it's a change, or maybe they're a person who likes to get a little bit more for a little bit less. And so they're happy to ask you to see if you'll do it. And if you're willing to do it, why not? But maybe they don't feel like it's so important when you tell them, yeah, I'll do that, but you have to pay for it, And so that's why I'd say if you have personnel on the ground who are being asked, hey, will you do this? Will you do that? Will you do this? They should be checking with someone before they say yes, because they want to make sure that, like, is that part of our scope of work? Or is that not, like, because like we've all been there, you're out there, you're like, I mean, I can do that. I can do a lot of things, but like, is that what I'm supposed to be doing, sort of thing? And so that's where whether you want to call it your site manager or your project manager on your team should be, able to talk to them and be like, okay, but like, that's not in our drawings. That's not on our scope of work. That's not something, the service you've requested. And if that's the case, and it's not something that's already been part of the contract, that project manager or site manager, or whatever title you want to give that person, should, whoever from the government is asking to do it, should ask them, saying, is this, this is in our drawing specifications, our scope of work, our contract. That would appear to be a change to us. Is this coming from the contracting officer? And if that person's like, I don't know, it's just something I saw that would make sense, that's a red flag. But also, even if they say, yes, it is, then that's where you go and you either call the contracting officer immediately and say, look, they're saying this is coming from you. That's a change to the contract. So it'll cost extra, but we're happy to do it, or it'll take more time, but we're happy to do it. Are you planning to implement a contract mod for that? And then based on that call, that's when you then send an email saying, thanks for the call today. Just to document it, your whatever title person came by the site today, asked us to also do X, Y, and Z, which means our price is going to change by this. Our period of performance is going to change by this. Looking forward to the contract mod, that you said would be forthcoming. And that way you've documented that it's forthcoming. They very well may say, hey, you got to submit a request for equitable adjustment. Like, we're not going to do a contract mod, but if that's what you need, submit a request for equitable adjustment where you document in there, here was the original scope of the contract. Here's what's now being asked to do. That requires this, which means it requires X number of people to spend X number of hours at this hourly rate. So that's that, plus the indirect cost, overhead, profit, blah, blah, blah. But also, because I'm taking these 3 people from doing Y to now doing Z, that means that I need to get an additional 3 or 4 days, weeks, months, whatever, before I add it onto the period of the contract. And you submit that into the request for equitable adjustment. And then there's usually some negotiation based on that, or they approve it. And then the contract mod documents that request for equitable adjustment.
And so that would be the same methodology or strategy if I were in IT, on several IT projects that I've been on. As an end user, you start to see all of these great implementations and efficiencies being implemented by a customization of, off-the-shelf products. And then your mind starts to think, oh, wow, if when this is complete, I could also perhaps have a certain type of reporting module added onto it that I'll be able to do, certain types of dashboards. And you end up starting to talk to the programmer, hey, will the system also be able to pull this, this, and this if I'm pulling from a certain type of data warehouse to be able to generate certain types of analysis that, again, the business owner or the technical programmer from the company that's providing the support may say, just like you said, hey, yeah, we can do that. However, that also requires a certain modification on the back end of X, Y, and Z. So what I want people to hear is that it's somewhat of the same methodology, even 100%. Across the industry. Okay.
Well, I think, from what you were just saying, I mean, can my software do this? Yeah, if you want to pay for it. I mean, a simple one for me is like in Microsoft Teams, if you have the basic one, there are certain features available. But if you want to pay more for Pro, there are more features available. And so if the government purchases your software at the basic level and then says, but can it do this, this, and that? And you'll go, yeah, but that's the Pro level. And the Pro level costs this. You're only paying for this. That's clearly a contract mod, because if they want to start implementing the Pro level, then sure. Is it reasonably contemplated in the contract that they might want Pro versus basic? I think that would be something that could be a contract change and not a cardinal change, it would just let them know, okay, you're buying 17 licenses that were originally at $40 a license per year, but now it's going to be $65 a license per year. So therefore, your price is now Z, and that's a contract mod. That's a super gross simplification in the IT world of just like software. But similarly, if you're designing an entire IT ecosystem for them, and then the person who will actually be using it, which this never happens, of course, but the person actually going to be using it looks and he goes, yeah, that's great, but like, what do I do with it when I need to do this? Can your software do that? And you're like, well, yeah, my software can do that, but you didn't ask for that. And so then it turns into, okay, if you want me to do that, I have to do X amount of additional programming, or I have to go buy X amount of equipment, and I have to configure the cabling, I have to put it in the right spot, and I have to, program how it's going to, do exactly that. That's fine, but that's definitely a contract change. And so then, and I will say that I am not the IT person. So this is where I would talk to my IT client and go, okay, for whether it's a general scope or whether it's a cardinal change, talk to them going, okay, based on the original specifications they gave you, the scope of work provided, what wants and needs, would you have reasonably contemplated they could have also wanted this? So therefore, that's something that's relatively easy for you to now do, or would it require you to totally start over and start programming from scratch because now they're taking you a totally different direction? Because then that's probably a cardinal change if you have to trash the code you already wrote and rewrite new code. Because I'm not a programmer, I'm not a code writer, but I'm sure that there are certain things where you're like, yeah, I could do that if you told me 10 weeks ago when I was on page 1 of code, not page 1100 of code. And now because you want that tied in, I'll have to go back through and line by line, re-edit 11,000 lines of code for this to work. Maybe that's the cardinal change because you're making me start from scratch again. Or maybe it's not that hard, but that's where you have to present to the government what you're asking for is doable, but here's what it'll cost you in time and in money. And then they have to document that via a contract mod for it to be captured. But that's where saying yes, because you always want to say yes to the government. I agree. Like, sometimes it's important to say no. But when you're that business owner and you want to be there you want to make them happy, the instinct is you always want to say yes. But it's okay to say yes, but, which is yes, I can do that, but it has a cost associated with it. And we need to talk about, are you paying for that cost?
Okay, cool. All right. Thanks for the clarification. I'll go back into stuff now. Okay.
Hopefully it's slightly clearer than mud now.
It's a lot clearer. Thank you.
Yeah, of course. All right, so next up we have express terms. So express terms are generally, meant to be as clear as possible, very succinct, very precise. And then so you run into sometimes changes when contract is unclear or the contract documents do not resolve ambiguity. This can be in the specifications, the drawings, industry standards that the government is requesting to be applied or fall under, mil specs or any other reference documents. This gets into what we were just talking about in IT projects. Especially now with various CUI requirements, NIST requirements, CMMC, you start to have more and more industry standards, more and more specifications, and more requirements that are imposed on there. And so if the contract is not clear as to exactly what it must fall under, and now you as an expert in doing that has to go back and start asking questions like, well, your scope of work says to do A, B, and C, but under NIST 800-171, I really should be doing D and F. That's an important conversation to have with the government. And that's where this often comes up when you're reviewing the initial bid package, the solicitation, the RFP. And this is where you want to submit what's called a request for information or participate in the Q&A prior to submitting your bid. This is very important because some of these things, it's part of that contractor's duty to inspect and to make sure you understand what was going on. So after contract award, and now you're doing performance, you suddenly are like, well, wait a second, you didn't have the right specification in their industry standard in there. The government may challenge it based on the fact that you knew about that prior to submitting your bid, so you could have corrected it up front, or you could have asked that as part of an RFI or a Q&A. And so you really want to do this before submitting your bid. You want to make sure when you read through the specifications, you read through the drawings, you read through the scope of work, everything in there makes sense to you and seems like it aligns, because this is your best chance to correct that prior to bid submission and prior to contract award. Importantly, you don't want to rely just on what's called an order of precedence clause in the contract. Those usually tell you, in the case of conflict of data or ambiguity, rely on the documents in the following order, where you start with document A, then document B, then document C, then document E. It attempts to resolve conflicts, or attempts to resolve ambiguity within a set contract, but not all construction or not all IT and not all contracts necessarily contain that order of precedence clause. So you can't hope that one will show up. So you want to make sure that you're asking that question. And even if that question is answered to you based on it, some reference to an order of precedent and telling you which document, at least you know about that before you submit your bid. Under FAR 52.215-8, any inconsistency in the solicitation or contract shall be resolved by giving precedence in the following order. So this is just the default, but not all contracts may contain this FAR clause. The default order is the schedule or that scope of work, representations and other instructions, contract clauses, other documents, exhibits, and attachments, and then finally, last is the specifications. So you have a duty to inquire if there's ambiguity when reviewing the bid package. And you want to make sure as you go through those, schedules or scope of work, any representations by the government or any instructions by the government, FAR clauses, DFARs, et cetera, or other contract clauses, any attachments, exhibits, documents that included, and then the specifications, that if you go through all those, would you perform the project without asking any questions? If the answer is no, or if you're unsure, or you might have to make an assumption based on, I've been doing this for 35 years. Every time it says this, what they really want me to do is this. That's still ambiguity. You may know it, and that's fine to put in a Q&A of, I'm reading this. In my experience, that means you want me to do X, Y, and Z. Please confirm that's what you mean by that, and make the government put that in writing, because answers to Q&As are typically incorporated into the contract and something that you can rely upon as you perform a contract awarded to you. Defective specifications are unfortunately more common than they should be. The bid package and contract documents must tell you exactly how the contract is to proceed. And this is because there should be no ambiguity. The government should know exactly what it wants. The government relies upon experts in drafting specifications and drafting contracts, and they should be able to take you on a map of exactly what you have to do, so you know what you're getting into before you bid on it and before you're awarded a contract. If the government design does not work, the specifications are defective. If you look at that contract design, whether it's IT and the way they seem to want components to interact will never actually function, or will overheat, or they're calling stuff by the wrong equipment number, or they're saying that the wrong specification applies, that's a defective design, or the specifications are defective. The government bears the risk that its design is defective, not the contract. So this means that if the government presents to you a defective design, that's on them, and so it's for them to resolve. The contractor cannot have known of the defective design prior to bidding. If it's something that under the contractor's duty to inquire and to review would have been, facially obvious or, facially recognizable, so the contractor knew there was a defective design, bid on it anyway, then you start to have a challenge in bringing a claim against the government based on what you have to do later on to correct that. However, you are allowed to propose changes to resolve defective specifications. This gets into the RFI. This gets into the Q&A. You ask these questions based on what you've seen. You try to get clarity from the government. Based on clarity from the government, you can propose a change to their specification saying, based on the contract, based on the specifications, based on your answer to my RFI or my Q&A, I would propose that the following changes be made for smooth performance and to resolve ambiguity. If the government doesn't act, then they're taking that risk again. But you've done everything you can to try to present that clarification prior to contract award. Again, prior to acting upon a proposed change, you have to notify the government and get permission. And if you are able to present a change that results in some manner of savings under a value engineering clause in your contract, you're actually able to receive some share of those savings. These are very specific to value engineering contracts, but you can get something from that. That's why it's important to present that analysis, present your recommendation to the government. Government interference, we talked about this before. Government actions impede your ability to perform. This can be based on design or specifications. Again, if it's something you knew about up front and you elected not to act upon, this is a defense they may bring. But if you present it to the government and they didn't do anything about it, or if it's not something they would have been able to see on the face, but you discovered it once you got on site or you started performing the contract, and this is something that's government interference, which will entitle you to time and/or money compensation. It also occurs when the government oversteps its authority and presents a demand of the contractor that the contractor is not required to do. So this is where we get into what Maria and I were talking about earlier. As much as we are always eager to say yes and eager to keep the government happy and eager to keep the contracting officer's technical representative, or the contract specialist happy, you are not obligated to, nor should you just quietly follow everything they say. They are not always delegated or authorized to impose a contract change, as we talked about previously. So if they bring something to you and they say they want something done and they're saying it must be done, that's where you need to go back to the contracting officer in writing and make sure that the demand or the request of the coder or the CS is in fact a change, and in fact a change the government's going to incorporate into the contract. You also must, as we discussed, inform the contracting officer that the demand by one of their agents will incur an extra cost, and that cost includes time. So things to consider when you're proposing solutions. Does the proposed design conform with the contract? Will the proposed change cost you time or money? This is a way to determine, is it a general scope change or a cardinal change? And is it a change that will require a contract modification? You're always obligated to comply with the contract specifications. You are not, however, obligated to make every possible improvement to the project. What that means is, it's based on your 30 years of experience, as you're working through the project, you see that they asked for A, and A is good, but B would be better. You don't have to make that improvement. They can pay for that improvement. They can pay for that change. You can recommend that change to them. And if they want to do it, they can make that change. But just because as you're going through it, there's a better way to do it, but that better way is not in compliance with the contract specification, you're not obligated to do it the better way. If you're spotting stuff that, the specification is not in conformance with industry standard, that's something why it's important to review it up front, so you can make sure you're letting them know they're falling below an industry standard, and they should make the following changes to adhere with industry standards for you. Other common interferences that I see: over inspection. If they're on site every single day looking over your shoulder like you're trying to work on something and your dog's head's right in your face, so you can't get your work done, that's interference. That's compensable. If they show up and they want to keep dragging you into a room to do meetings with everybody and so they can't do their work, if they're asking you to stop work because they need to have a meeting or they need to do a site visit or they need to do whatever, anything that causes a disruption to your work based on government's direct action, and it can be indirect action of not stopping something, but if the government causes that disruption of work, that is a change that should be compensable. And again, as I said, failure to timely respond. If you're on site, differing site condition, something you could not have found up front, or you discover something that's in the specification, but it's unsafe, not industry standard, or something that's ambiguous, and you reach out to them and ask them for clarity on how to proceed, and they take forever to proceed, so you're just stuck sitting around twiddling your thumbs, that is also something that can fall under an REA based on a failure to timely respond or reasonably respond, causes a change to the contract, which causes time or money to need to be increased or decreased for the contract. Failure to cooperate and constructive acceleration. Failure to cooperation, failure to provide access to promised facilities, access required spaces, water hookups, power, etc. Failure to provide government property, equipment, and materials that were promised in the contract. Failure to disclose relevant information. That could be part of a defective specification, or that there's a certain space, like if you're working on a skiff, that you would only have access to during a set window of time, and you planned on having it 24/7, but you only get 2 hours a day. That's relevant information to your contract. Failure to resolve conflicts with other contractors. If you're one of multiple contractors working on the same facility, and you need to be able to drive a crane back and forth, but they're laying asphalt, and so you can't drive a crane. They haven't resolved conflicts with those contractors. That's causing a delay. That's causing an increase in price. Those are failure to cooperate. Constructive acceleration. This typically occurs where the government denies additional period of performance time, or in conjunction with a contract change. You'll see this where, based on one of the above failure to cooperate or one of the other changes, you need an additional 15, 20 days. They say no. And so now you expect to be working 8 hours a day. You have to work 14 hours a day to get done on time. So you're paying overtime, or you're hiring more employees. So that increases the cost. That's a constructive acceleration of the contract. And so that's typically where you need to ask for money based on that constructive acceleration to still get it done based on the period of performance that the government's allowing for you. The government, in its specifications, in its design work, in its contract, should allow adequate phasing to ensure there's no conflict with other contractors, as well as the availability of all required facilities. The government best knows how many contractors it has working, what all they need, where they'll be, because it has all the specifications and all the drawings and all the scope of works in front of it. Same thing with knowing access availability to facilities. So the government's burden is to make sure that's all been phased and all of it has been, scheduled to be in coordination. Similarly, the government is required to provide all relevant information that will affect the contractor's ability to perform under the contract. We've gone over a lot of that, but this all falls under the government as well. And that's, access windows or access requirements, or, if it requires a key card or a physical key, or if someone has to be present to let you in and out. These are all important pieces of information that the government should provide to you. The contractor must request both an increase in monetary costs of a change as well as an increase in period of performance for the same change, if both exist. Doesn't always work out the way where it has to be both time and money, but if you need both, you must address both. Where the government denies additional time, as we discussed, that's a constructive acceleration. So it's important to detail to them that why you need the money and why you need the time. If as a result, and they do the contract modification and they only do the money and not the time, then that's still an REA where you're now claiming a constructive acceleration, explaining why the denied additional time requires you to get even more money under the contract so that they can understand what their constructive acceleration is causing. Next up, we have, most important to me, it's document. We start with external. External documentation means notification to the contracting officer as soon as reasonably possible of any changes you're experiencing, any constructive changes, directive changes, what's causing it and why you think it's a change. And that could be those conversations or anything else. Make it clear. This is so important. Even though you said, yes, I can do that, make it clear you're not volunteering to do additional work or to complete work earlier or later than specified in the contract. I.e., yes, I can complete it earlier. Yes, I can complete it later. Yes, I can do more work. Yes, I can do less work. But here's how it will change the cost, and here's how it will change the period of performance. You submit this to them via change notice. These are relatively simple letters. We draft them for our clients all the time. And so you submit it to them, and it's that notice of change to the contracting officer that details all these requirements. Then we follow up a change notice with a request for equitable adjustment, cites the same information that's included in the change notice with a little bit of case law added in there saying, here's where it started, here's where it finished, and here's the reasoning why. You present that to the contracting officer, and that's where they make their determination about a contract mod. Obviously, if they just come out the gate with a contract mod for their change, it's a slightly different process because they've already done the change. But if that change doesn't account for excess cost or period of performance, you still are going to present to them a request for equitable adjustment based on that change to the contract that they presented to you. Next is the internal documentation. Do record all government action. This is meeting minutes from conversations with the contracting officer, the technical representative, contract specialist, or any other person from the government that's having conversations with you or your team about project performance, what's being done, what they want to see done. Get it all written down. Make sure it's in meeting minutes for any of those conversations. You want to make sure that you are informing the contracting officer promptly that something is being changed, even if you've not yet incurred all costs related to that change. You want to put the contracting officer on notice that there is a change that's occurring. This can be due to failure to respond in a reasonable or timely manner. This can be due to interference. This could be any of those items on there, just saying, look, this is happening. It's disrupting our work. It's delaying our work. It's causing us to incur a higher cost, or, it's going to make it take more time. You may not know exactly how much yet, but you want to put them on notice as quickly as possible that is happening so they can try to resolve it rather than having it go ongoing and you're trying to capture that in an ongoing basis. Be complete and precise in your records. This is so important because when you do that REA and you present to the contracting officer, you want to be able to present to them exhibits and attachments that detail support for exactly why you're asking for that dollar value and why you're asking for that time value. This is important to get it resolved quickly with the contracting officer, but also it's important to be precise to avoid a false claim. And then record all additional work and costs and internal actions in response to that change. This is all just supporting documentation to justify why you're asking for more money or time. Do not overlook indirect effects of a change. This means that, based on their failure to respond, you had extra porta potties, or you had extra people on standby, or you had people that couldn't work on another project, or you had to hire more people. These are the second and third order effects that still have cost to you. If based on a change, you have any cost, monetary or time, don't overlook it as it's not directly what they did, but it's indirectly. And so you need to be aware of that and document that. Any change, do not think that any change is insignificant or inconsequential. Document it. The government will ask you for 100% of what you promised in the contract, and you should be asking the government for 100% of what their change costs you in time and money. Don't assume the government won't try for free stuff, and don't assume that estimated costs, to allow room to negotiate is okay. You should not do that because estimated cost to allow room for negotiation is the definition of a false claim. And under the False Claim Act, if you do that, you have treble damages coming back your way. So we had a scenario where a bid was won for a road, and it was a $3 million contract. And shortly thereafter, an REA got submitted because of various reasons that they just declared it would take another $7 million to get that road done. Goes to via a contract claim in court, the contractor testifying, they say, what is the basis for it being $7 million? And the contractor said, oh, that was just to start the negotiations. It actually won't cost that much. That hearing stopped. False Claim Act started immediately based on testimony. They now have a $21 million fine because they estimated and they didn't have certified costs. Don't do that. Please don't do that. Marie.
Yeah, please don't do that. So, but to go back, a couple call outs that I want to make, and this actually goes back to several virtual trainings ago that we did. And it ties to the documentation.
Yeah.
If there's a contract, zapping, I'll put it that way, if your contract gets terminated or, there's a stop work order, and it's the being able to document the costs, right? And the tasks that are now on hold. I'm kind of seeing this common thread, so I'm going to have to pull in an accountant here in the very near future to talk about those types of databases and systems to be able to track that. One thing I really want to call out, this would actually be more for the manufacturing side of the house, Chris. Now I'm manufacturing parts. I'm manufacturing parts maybe for NASA, for energy, for Department of Defense, and it could go into any kind of systems type work. So I'm given drawings And, it's research, it's R&D. And so now I'm given these specs for a part, and I go ahead and I manufacture it to spec, given to me by the government engineer, and the government engineer, receives the part. They go ahead and try to implement the part, and then they realize, oops, I didn't do something right. Right there needs to be a modification made on that part. But they come back to the supplier and they say, well, we need you to remake it based on these new configurations now.
Sure.
That's a change order to my contract. That's a question.
Yeah.
And if so, do I need to reach out to the contracting officer and say, hey, technical line has approached me to do rework on this. I need
Sure.
the contract extended and those kind of things.
Yeah, so I think oftentimes this is resolved because in contracts that have very specific things being made, they oftentimes do a first article test where you have to produce a certain number. And the first step of the contract is they give you X amount of time to produce a first article that meets the government's requirements. And once the government approves that, then you proceed on to the first period where you produce X number for them. And so oftentimes that's how that is avoided, having this is done as part of it. However, yes, if the specifications or the drawings and the scope of work and everything else, you follow the contract precisely and you produce exactly what the government wants, and it shows up and goes, that's not it. We need it to be done differently. And now they give you new specifications, or they tweak the specification, or they tweak one thing and you start from scratch. That's absolutely a change. Some could argue it goes into the realm of a cardinal change because you're starting over from scratch, but it depends on, is that just one facet of the contract, or is that the sole purpose of the contract? And so some of those factors go into it. But yeah, I think you say, yeah, we can make you a new one. However, that is a change because now it'll cost us this much money to make you a new one, including our profit overhead, et cetera. And it'll take us this long to make a new one. And then you have to also confirm with your supplier or your manufacturer, are you even available still? Because theoretically, they're just making one. They've already satisfied their subcontract to you, and maybe they fully retooled and set up their manufacturing to do their next contract, and they need to stop that and start over. You may have a higher cost associated with that as well. So,
okay.
I think in that circumstance, it's a tougher answer because usually if there's a risk of something like that occurring where their design may not quite meet their need, they do a first article test and have you do that before they start the real production run for it. And so that's how it'll be avoided. But I think in that one, I would, if a client came to me with that, I would want to see the contract, the specifications, and to better advise them, is this a cardinal change? Is this not a cardinal change? Yeah, REA, but we have a lot of documents we want to get together first to present that to the government when they're coming back to you. And so I think that one's a tricky one.
Okay, cool. Okay, so that's a pick up the phone and call Chris. No.
That's a tough one to just say, because as I said, it depends. Is a widget that they're redesigned 100% of the contract, or is it 1% of the contract? That can factor into as well. Yeah.
Okay, cool. Great. Okay. Stealth mode.
That's good. We're nearing the end. I've been talking for a while, so I'm sure you guys are ready to give your ears a break as well. I'm going to go quickly on REA and filing a claim. I'll be doing follow-up training specifically on REAs and specifically on filing a claim. But ultimately, at the end of this contract change, unless the government on its own issues this contract mod and it already perfectly encaptures the price and the time required, you're going to be asked to sit, or you not asked always, they'll be happy if you don't do it, but you should submit a request for equitable adjustment or an REA. This is following the change notice. The contractor should submit an REA, which includes factual and legal support for the equitable adjustment requested, time and or money. REAs can be subject to audit. REAs can require certification, but you must file them as soon as practicable to confirm the contract change clause does not have a specific time limit. And that's where these different contract changes clauses have different time limits associated with that. The CEO must respond as soon as practical, and the costs associated with preparing and submitting the REA are recoverable as contract administrative costs. That's why it's important to do this step, because that way, when your attorney charges you however much money to draft this REA and negotiate it with the government, their fees are part of that negotiation, and their fees are compensable to you and not just lost money or lost profit on the contract. And so key elements, as I talked about, facts and law supporting entitlement. When was the work ordered? Did the person ordering the work have authority to order that work? When was the notice given to the government that this was a change? Was the government prejudiced by late notice? What effect to the government order? What effect does the government order have on cost performance? Quantum and proof of adjustment. Increased costs directly attributable to work added by the change. Deduction of costs for work eliminated by the change. And application of overhead and profit to the net cost directly attributable to the change. So that's what you'll need to include as part of this REA. To prove your REA, that's where we talk about contemporaneous documentation, as we went over previously, document, letters, emails, invoices, correspondence with suppliers, manufacturers, all of this needs to be in there. As necessary, any witnesses to the request being made by the government. If the government's denying, they ask for that change. Support for your cost impacts, any basis of estimate, any estimates for time to complete, any actual costs that you can present to them, and then change order accounting may be required or preferred depending on the contract cause and the value for that, as well as the profit that you're including in there. These are all things that we say are why you want somebody like a Chris or like some other attorney to be involved, because we do a lot of these. We see the responses from the government. We know where these REAs fall short. I know I went through that very fast, but this one will be its own little bite-sized learning in the future to talk about preparing REAs, what to include, common pitfalls, best practices, and what to see. So please stay tuned for that. Following an REA, if the government denies your request for equitable adjustment, then you can file a claim. These claims are where you actually ask for a contracting officer's final decision. You certify the value. In a claim, you're going to include factual and legal support for the equitable adjustment that you requested. Your claims, again, can be subject to audit and certification. Claims are subject to certification and must be some certain when they're greater than 100K. Denials of a claim can be appealed to the Court of Federal Claims and/or the Board of Contract Appeals. You have 90 days from contracting officer final decision to file a notice of appeal to go to the Board of Contract Appeals, and you have 1 year if you're going to go to the Court of Federal Claims. So it's very important to recognize when a denial happens. Your claim must be filed within 6 years of accrual of the claim, and the CO response is due in 60 days if the claim is for less than 100K. If it's more than 100K, they still want to do 60 days. However, they just need to notify the contractor when they'll reasonably have a response to your claim back to you. And so they have a little bit more wiggle room on that. However, once you're in the claim field, your costs associated with preparing and filing a claim are not recoverable as part of that claim. And that's why we want to do as much of the work as possible in preparing the REA to minimize the amount of cost in preparing the claim. Because once you file a claim with the Board of Contract Appeals or Court of Federal Claims, you oftentimes are going through discovery and you're doing depositions and you're making either arguments or you're drafting motions for summary disposition and responses, and it can get very expensive. So you want to do as much of the legwork as part of the REA to create the framework and the map for your claim. That's all I have for you today. On this, I'm sure there are more questions that are raised by that. I always do a plug for this. For NVSBC members, I offer 2 hours free of legal work. And so that's something where we can talk about the scope of what can be done in 2 hours. And beyond that, my phone's always on, my email's always there. If you have questions, please reach out. If we have to reach a point where you're hiring me and paying me, you'll know that well in advance. But I'd much rather you have the comfort of reaching out to get some advice or some understanding rather than being afraid that you can't afford to have me even pick up the phone to talk to you. We'll make sure you get taken care of. and we'll make sure you're in the right spot.
Cool. Thank you so much, Chris. This has been great. A wonderful start into a great deep dive that we're going to be doing even more virtual training series on. So everyone, stay tuned. There's more from Chris and Clark Hill, and lots going on in the world of GovCon, as you can see, and lots for you to keep track of. And so, Chris, with that, I am going to call this one a wrap, and I'm going to say ciao for now, everyone, and we'll see you at the next virtual training. Bye-bye.
Thanks all.